Gerbiami konferencijos dalyviai.
Ladies and gentlemen, let us continue with our conference on the division of powers. I am Toma Birvondinė, a moderator of the second part of the conference, together with my colleague Haroldas Šimkūnas. This part is dedicated to our guests, who, due to the reasons that we all understand, we're not all able to join us physically, and therefore in the second part we will be speaking both languages, Lithuanian and English. And our first guest and speaker is Professor Alexander Vashkevich from the European Humanities University in Lithuania. He is also former judge of the Constitutional Court in Belarus. The topic of his presentation is dedicated to the principle of separation of powers in the Constitution, in theory and in practice.
Our conference, and this conference will be moderated by me, Toma Birmontienė, and my dear colleague Haroldas Šimkūnas. We are starting this the second part of the conference, and there will be a possibility to have very interesting presentations that our guests from different other countries will present. And first is our friend and colleague Alexander Vashkevich. He is professor of European Humanities University that is placed in Lithuania, and his presentation is Principle of Separation of Powers in the Constitution of Belarus, Theory and Practice. So please, floor is yours.
Thank you, Professor Birmontienė. Hello, dear colleagues. First of all, I would like to thank organizers of this conference for inviting me to speak here at this distinguished place, I would say. Of course, topic is very broad, so I would just put your attention to some peculiar features of the Belarusian form of government, as I am agreed with Professor Misonis, who thinks that this principle of separation of powers and form of government are linked together. So just few features, and my main thesis would be that the current form of government, as we have in Belarus, is just the old Soviet form of government with some slight transformations. Let me first briefly speak about the history of the development of this principle, and you might know that the history of Belarusian constitutionalism in the 20th century knows 5 Belarusian constitutions that were adopted in 1919, 1927, 1937, 1978, and 1994. And probably you know that until 1991, Belarus was a part of a former Soviet empire, and all of these constitutions adopted at this time were just enshrined the Soviet form of government. And as you know, probably one of the most important features of the Soviet form of government was the complete denial of the principle of the separation of powers. It was named, I remember, in the old textbooks as so-called bourgeois principle of the separation of powers, and it was sharply criticized by the Soviet lawyers and people who wrote textbooks. In the Constitution of 1978, it was proclaimed that the Soviet Belarusian state is organized and functions on the principle of democratic centralism, namely the effectiveness of all bodies of state authority from the lowest to the highest, their accountability to the people, and the obligation of lower bodies to observe the decisions of higher ones. So formally, people exercise state power through Soviets of people's deputies, and in theory, all other state bodies were under the control and accountable to the Soviets. In practice, however, you know that the real power belonged to political bureau of the Communist Party of the USSR, then the only party that was officially proclaimed the leading and guiding force of the Soviet society. So this was changed in 1990, because it was for the first time that when the principle of the separation of powers was mentioned at the declaration of state sovereignty of Belarus. And this declaration was first adopted on July 27, 1990, and from August 25, 1991, when the Communist Party lost its power, this declaration was given by the parliament the highest legal force in the hierarchy of legal acts. So it's interesting that this declaration at the time was higher than the constitution of the country. And in this document, it was proclaimed that the separation of legislative, executive, and judicial power is the most important principle of the functioning of the Republic of Belarus as a rule of law state. Then from 91 to 94, it was a rather peculiar form of government in Belarus. To my mind, it was anyway parliamentary republic, but what was peculiar that the speaker of the parliament was at the same time the head of the state. Mr. Vashkevich was the head of the state at that time, so he combined these two powers, which is itself is in a slight contradiction with the principle of the separation of powers. Then, on the basis of this declaration, the Constitution of Belarus was elaborated and adopted on March 15, 1994. And again, the principle of the separation of powers was enshrined in the Constitution in Article 6. The state is based on separation of powers, on the principle of separation of powers, legislative, executive, and judicial. State bodies are independent within their powers. They interact with each other, restrain and balance each other. So it's a classical notion, I would say. And according to the Constitution, I would say it was semi-presidential form of government, again with a strong parliament, but at the same time a very strong president as well. Unfortunately, this system of government was in force only for 2 years, because in November 96, a constitutional referendum initiated by the president Alexander Lukashenko took place. And though, according to the judgment of the Constitutional Court of Belarus, it was declared inconsistent with the constitution, this judgment was ignored by Lukashenko, so changes of the constitution took place, and in practice it was a completely new constitution, because the form of government was transformed into a super-presidential form of government, with the complete absence of the rule of law, no real separation of powers, and absolute power of the one person, president. And this form of government was indeed a real Lukashenko's idea in practice of the ideal state, and he believes that the best form of government is such when the head of the state stands above all other branches of power, and he controls them, but not vice versa. I'm always surprised when some Belarusian, I would say majority of Belarusian constitutionalists could say that they have a presidential form of government in the country. This is complete nonsense, because you shouldn't compare, let me say, American form of government, which is presidential, classical example of the presidential form of government, and Belarusian one. Lukashenko, so he simply used the former Soviet system as a template for his regime, because he knows only this system. He's used to it, and there is only a slight difference. Instead of the Politburo, which was anyway a collegial body, I was surprised, for example, when they discussed at the Politburo the invasion to Afghanistan. They took several debates, and they voted several times, and finally some people were insisted on this decision. But we have president as a one-man Politburo, and his administration plays a role similar to the Central Committee of the CPSU. It is, I would say, very symbolic that the building of the former Central Committee of the Communist Party of Belarus, after a temporary ban of its activities in 1991, was firstly occupied by the Supreme Council of Belarus, by the parliament, but already in 1995, at the request of the president, parliament left the building and was forced to move back to its traditional building. And do you know where the parliament of Belarus is located, actually? In the so-called House of Government. Indeed, they share their building. On one wing it's a government, another wing is a parliament, so it's very, very useful. So now you know who occupied the Central Committee building. Of course, it's the presidential administration. Not the president himself, but the presidential administration. So it's very, very similar to the Soviet times. Now I would say a few words about legal status of the president and government. Again, you would be probably tired and would sleep if I would start to mention all his powers. So I would save your attention and would name just a few. He is head of the state, guarantor of the Constitution of the Republic of Belarus and the rights and liberties of man and citizen. He always speaking against the creation of the ombudsman office in Belarus, telling that he is the main ombudsman, and there is absolutely no need to have something like this in the country. He personify the unity of the nation, the implementation of the main guidelines of domestic and foreign policy, shall represent the state in relations with other states and international organizations, shall provide the protection of the sovereignty of Belarus and its national security and territorial integrity, shall ensure its political and economic stability, and the continuity and interaction of bodies of state power, and shall intermediate among the bodies of state power. He enjoys immunity, and his honor and dignity is protected by the law. In practice, his powers are unlimited because he appoints and dismisses representatives of all branches of power, including the government, all judges, the Procurator General, the head of State Control Committee, the chairperson and members of the board of the National Bank, the chairperson and majority of members of the Central Commission on Election and National Referenda, all heads of local executive and administrative bodies, and other officials whose offices are determined by the law. He is the head of the Security Council of the Republic of Belarus and Commander-in-Chief of the Armed Forces. He has the authority to call national referenda and to declare them obligatory or consultative, to call regular and extraordinary elections of both chambers of parliament as well as of local representative bodies, and he has the power to dissolve the parliament. Dear colleagues, I am speaking about the powers of the Belarusian president. Probably you understand this. It's interesting that after this very, I would say, broad list of his competencies in the Constitution, there is a last notion in this article that his powers could be supplemented and expanded by means of adopting a law. So, in practice, there are no limits of his power, even according to the Constitution. Briefly speaking about his relations with the government, he appointed the Prime Minister, and the Prime Minister should be confirmed by the lower chamber of Parliament, but if the House of Representatives rejects the candidate twice, the President is entitled to appoint him anyway and to dissolve the Parliament, and call new elections. He also entitled to call for the resignation of the government on his own initiative at any time of the year and of the parliamentary year, and to appoint and dismiss any member of the government. So, in practice, the principle of the governmental responsibility before the parliament doesn't work at all. Formally, according to the parliamentary rules, the MPs have the right for the parliamentary inquiry. And I even remember the times that at the end of the 90s, it was 1 or 2 parliamentary inquiries at that time, compared, for example, in 10,000 with the Polish government or so, and not now. I would say I spent a lot of time trying to find one, but I didn't succeed. Another peculiar feature of the parliament is that they do not have public records of their proceedings. So it's impossible for you just to know how your representative was voting or what he told at the session. The president, which is also strange, has the right to legislate. He is a legislator as well as the parliament, but in practice he is the only legislator, as 100% of the parliamentary bills are initiated by himself or on his request by the government. Again, I couldn't find any example of the parliamentary initiative by itself. Though formally, according to the Constitution, members of the parliament have the right to initiate the legislative procedure, but they have no chance to do this because in the Constitution they have a norm that all laws, just a second, I would find you because it's a peculiar norm. So if the draft law might reduce state resources or involve or increase expenditure, could be introduced only with the consent of the president. So if you need to print a law, a draft, you need probably to make some, to give some money for this. So of course it's need an expenditure, and so there is a need to ask president just for the permission to introduce the law, but it's also impossible in practice due to the fact that from 1997 this Center for Legislative Activities is also under the presidential auspices, and he nominates the head of this institution, and every year president by his decree introduces a plan of the legislative activity for the next year. So it's like this. But if by any chance, which is not highly probable, a norm is adopted and the president does not agree to it, the president can use his veto. Theoretically, a qualified majority of all members of both of the chambers, because formally we have two chambers in the parliament, can override it. But in practice, from 1997, there has not been a single example of an overridden veto, not example at all. Though it was used in the 90s, and now there is no need simply to use this institution, because all laws are adopted very smoothly, usually with unanimous vote. There is a strong consensus in the parliament, and you might imagine that in the parliament there are no fractions at all. In the 90s there were fractions, now there is no need probably in this, but anyway, no representative of parties are in the parliament anymore. Probably we're a little bit out of time, so I came to my conclusion. Just a few words about the role of the Constitutional Court, which in a democratic society might be this institution that just helps to check and balances the powers of the other authorities. And indeed, the Constitutional Court played such role until November 1996, before this constitutional referendum. But from now, just think about it. Since 1997, not a single legal act adopted by the President has been recognized as fully or partially unconstitutional. It was simply no such cases for the 23 years. Second example is that since 2008, the Constitutional Court was given a power to make a so-called preliminary control. And since then, the Constitutional Court has reviewed over 1,000 draft laws, over 1,000, probably 1,100, and it is rather interesting that any law or any single provision of the law had never ever been found to be contrary to the Constitution by this so-called Constitutional Court. So it's nothing more than I have to tell you, and the only thing to tell in the conclusion, even a brief analysis shows indeed the total lack of the separation of powers in Belarus, even on the level of the constitutional provisions as well as in practice. And I very much hope that in a year, during the next conference, I would sound more optimistic, very much hope this. Thank you for your attention.
Labai ačiū, gerbiamas profesor.
Thank you very much, Professor. Indeed, before the presentation, I had a word with Professor Vashkevich, and I asked him whether it's possible at all to speak about the separation of powers in modern Belarus. As you heard from the presentation, it was a sad, it featured a sad situation, but we hope for changes in our neighboring country. Next year, or maybe a little bit later, we have hopes that we will be able to be more optimistic about that. And I give the floor to Mr. Brabash from Ukraine, from National Law University in Ukraine, and his topic of attention is very intriguing. In fact, he's going to talk about whether it's at all possible for independent state agencies to remain independent in a system of strict separation of powers. What's the experience in Ukraine? The floor is yours.
don't understand a lot of things, but you talked about me. First of all, I would like, yes, first, do you hear me? It's okay? Yes, thank you. First of all, I would like to thank you for such opportunity to take part in such comprehensive conference. I'm very glad to see my big friends, especially Professor Toma Birmantiene, and understand that all of you are in good health. And unfortunately, we were not able to enjoy such obligatory scientific attributes of this wonderful conference, as I remember as Denis works in the wonderful Vilnius and live communication with friends. But I'm sure that in the next year, all of this will be in the real again. As you mentioned, my presentation will be devoted to the problem of the independent state agencies, which grows in the now official constitutional doctrine. I should say that among the constitutional doctrines, the doctrine of separation of powers is considered to be one of the most developed. However, there have been some complications with its applications in the practice of constitutional justice in the recent years due to the need to adapt to the lighter situation of creation and operation of the whole mechanism of so-called anti-corruption bodies, which were now inscribed in the existing executive system. However, before proceeding to describe the situation, let me make a few historical theoretical remarks. As the professor from Belarus said before, for 5 years of independence, we had to live according to a document that could not only be tentatively called a constitution, and which moreover we inherited from the times of the Soviet Empire. The fundamental law of the Ukrainian SSR of 1978, which survived the collapse of the USSR, denied the above-mentioned principle of separation of powers, recognizing the authority of the Soviets of People Deputies as a key principle of organized state power. It was recognized that all the other state bodies are under the control of and accountable to the Soviets of People's Deputies. In the absence of separation of power, it was perfectly normal for regional prosecutors, court chairmen, university directors, and directors of large enterprises to be members of parliament at the same time. The Presidium Verkhovna Rada was endowed with the competence to exercise constitutional control. The new constitution, which enshrines the principle according to which the state power in Ukraine was exercises in the principles of the division into legislative, executive, and judicial power, was supposed to put an end to it. It is difficult to say whether these principles was fully realized. However, the understanding that not only bodies fit into the traditional triad of powers according to the official constitutional doctrine that began to take shape became clear after the first decisions of the Constitutional Court. Analyzing the law of the accounting chamber, the Constitutional Court recognizes the existence of such an institution as a body of a special constitutional competence. This status could be given not only to the accounting chamber, but also to the Ombudsman, the Prosecutor Office, and the National Bank. Scientific thought also developed in the parallel course. Being captivated by stereotypical notions that outside the triad, the state power cannot exist. However, it became clear later that there are many other institutions in the mechanism of the state, and first of all, the president as the head of state in the semi-presidential and parliamentary republics. The discussion about the existence of separate special branches of government started citing the example of the Venezuelan constitution, for example, which provides for electoral power along with the 3 traditional branches of government. Domestic researchers have begun to suggest that the need for a separate control and supervisory authority. In general, both official and scientific doctrine began to form a false stereotype that power can exist only in the mode of its division into certain branches. A separate difficult issue was the interpretation of the evaluative construction used in the Constitution to determine the power status of the president. The fact is that in Ukraine, as in other post-Soviet states, acting at the time of the adoption of the fundamental law, the head of the state tried, on the one hand, to avoid responsibility for the state of the economy, and therefore formally this post was not related to the executive power. And on the other hand, they sought not to lose the levels of influence on the situation within the state and in foreign relations. So, at the constitutional level, they were assigned such powers as administrator of forest political activity of the state and administration in the spheres of national security and defense of the state. In general, his status was determined within the broadest, often incomprehensible limits. As we look to the Constitution, we should find that the President of Ukraine is the guarantor of state sovereignty and territorial integrity of Ukraine, the observation of the Constitution of Ukraine, and human and citizens' rights and freedoms. This assessment status allowed the President of Ukraine, under condition of a mixed form of government, to oppose himself to the Prime Minister from time to time, especially during the periods of so-called coexistence. One of such striking examples, which became the subject of the Constitutional Court's assessment, was the adoption of decrees by the President, according to which he gave himself the right to approve candidates for position in foreign relations bodies and in the structures of the Ministry of Defense. This assessment constructions allowed the Constitutional Court to conclude that the head of the state still has the right to use appropriate means of influencing foreign policy actors to ensure national security, in particular obligating them to coordinate appointments in the diplomatic service. Moreover, the court, for some strange reason, point to the possibility of applying the principle of direct effect of the Constitution by the President in such cases, interpreting his powers independently. The situation somehow changed after the Constitutional Court of Ukraine declared unconstitutional the procedure for establishment and operation of the National Commission for State Regulation of Energy and Public Utilities. According to the law on this commission, it was removed from the subordination of the President of Ukraine and endowed with the status of a permanent independent state's collegial body with exercises state power in areas defined by law. The Commission had a wide range of tasks, functions, and powers in the fields of state regulation, monitoring, and control over the activities of economic entities in the field of energy and public utilities. The law clearly established guarantees for the independence and autonomy of the Commission. The Court declared the law unconstitutional. Using the doctrine of rigid separation of power referring to the norm of the Constitution, the Court developed a legal position according to which formation of a permanent independent state collegial body, which according to its functional purpose, field of activity, powers, has the features, I should emphasize it, of a central executive body, but is not subordinated to the Cabinet of Ministers of Ukraine and does not belong to the system of executive bodies, does not comply with the Constitution of Ukraine. President Zelensky reacted to this approach of the court with an initiative to amend the Constitution in part of his powers to appoint heads of anti-corruption bodies who were removed from the executive branch in terms of their formation and subordination. However, this draft law came across a different dogmatic understanding of the separation of powers by the Constitutional Court of Ukraine. The latter considered it impossible to adopt such changes, referring to the fact that if the draft law is adopted, its provision could violate the balance of constitutional powers between the President of Ukraine and the Cabinet Minister of Ukraine, effectively creating a parallel executive branch accountable to the President of Ukraine. Moreover, according to the court, the draft law, in its part, empowering the President of Ukraine with additional powers uncharacteristic to his status to form new bodies with executive function and appoint their heads does not correspond to the essential content of constitutional restrictions on human rights in terms of their proper guarantee by the executive authorities and the President of Ukraine. In addition, the court in its decision even mentions the formula from French Declaration of Human Rights that a society in which human rights, you know about it, are not guaranteed and there is no separation of power, doesn't have a constitution. The next step in shaping such a doctrine was a resonance decision on the unconstitutionality of the provision of the law on the National Anti-Corruption Bureau regarding the appointment and dismissal of the Bureau's administration. It should be noted that impeachment law provided for the appointment of the Director of Bureau by President on the basis of result of a competition conducted by the Independent Commission, as well as a special guarantees against arbitrary dismissal, including the obligation to conduct periodic independent audits, the results of which could form grounds for dismissal of the Director of the Bureau. The court continued its doctrinal line in the issue of separation of powers, stating that the list of powers of the head of the state established in the Constitution of Ukraine, including the powers to appoint officials of bodies defined by the Constitution, is exhaustive. It also supported its argument about with the following points. The dispute procedure for appointing the Bureau's administration causes imbalance in the system of function of state power. It means system of check and balance. And as a consequence, the weakens the constitutional guarantee of human civil rights and freedoms, as well as a negative influence on the stability of the constitutional order. We must admit that within the court there has been a clear opposition to such a doctrinal approach, consisting of several judges who periodically oppose such a formal approach to the doctrine of separation of power. In particular, speaking with separate opinions, they emphasize several key points. First, the President of Ukraine, whether we like it or not, is involved in the exercise of executive power, including in resolving personal issues. Secondly, the doctrine of inherent powers which should result from the powers enshrined at the constitutional level and can be applied to the head of the state. And thirdly, in his national security leadership, he cannot stand aside from such national security issues as the fight against corruption. At this stage, we have to make several remarks of comparative and theoretical content. Thus, one of the debatable issues in the theory and practice of the US constitutional law has long been the question of the creation and function of so-called independent agencies. The emergence of such institution is historically associated with the period of the Great Depression in the United States, when there was a need to create independent regulators in market relations. One of the first in the formation of this doctrine of independent agencies was the decision on the case Humphrey Executive versus United States. The essence of the dispute was that President Franklin Roosevelt fired a member of the Federal Trade Commission, William Humphrey, on the grounds that the head of the state expected Humphrey to be more effective. It should be noted that the main task of this body is to prevent unfair competition in the trade. The commission consists of five members appointed by the president on the advice and consent of the Senate, and one political force may be represented by a maximum of 3 members of this commission. Instead, there was no such reason for dismissal in the law on the Federal Trade Commission, and thus, according to the applicant, the president violated the law. Several legal positions are important in the Supreme Court's decision on this case. First, the court emphasized that such independent agencies established by Parliament are not purely executive bodies, but are quasi-judicial and quasi-legislative. At the same time, and secondly, such circumstances don't mean that the Parliament takes over the power of the executive branch, as the head of the states retains the power to dismiss members of this body. So the law creates sufficient condition. For me, it's very important for the true independence of such agency by listing the exclusive grounds for dismissal, which are not subject to extended interpretation by the head of the state. I should say that in current times we should also talk in the same sense about such agencies as the Securities Stock Market Commission, Federal Communication Commission, which among other things licensed TV radio broadcast, the Board of Governors of Federal Reserve System, and so forth. Regarding theoretical discourse, we should note the extremely formal approach of the domestic constitutional court to the issue of separation of powers. First of all, the key foundational purpose of these principles of a constitutional order is to prevent the usurpation of all power by one institution or person, as well as to prevent the simultaneous presence of the same persons in different positions in bodies representing different branches of government. In fact, the point is that we had to abandon the practice of concentration of all powers in the hands of a national representative body, exercising deputy powers not on a professional or permanent basis, having deputies in position in the judiciary and executive bodies. The purpose of the principle is more global than to allocate all of the authorities according to the branches. The latter task of determining the places of all authorities without exception in the relevant branches seems to be a utopian mission in general, taking into account the more complex scheme of the power system that the one conceived more than 200 years ago by Montesquieu law. Therefore, in our opinion, the approach of the United States Supreme Court looks more reasonable and allows more maneuver for the government in order to solve complex issues institutionally, especially in the economic field, in the field of the fight with corruption. It is also appropriate to point out that unlike Ukraine, the United States government operates on the basis of separation of power in their pure form. Namely, there is no executive dualism and uncertainty with the position of presidential power in the traditional triad of powers. Thank you for more for such opportunity. Thank you for your attention, dear colleagues.
Thank you very much. And Yuri, aš norėčiau padėkoti mūsų svečiui.
I wanted to thank our guest, Mr. Yuri Barabash, for his presentation, for pointing out the problems that emerge. Now the question is whether the traditional principle of division of powers formulated historically should change in current times when different circumstances exist, when we have a different situation, and therefore independent institutions, including Ukraine's institutions fighting corruption, independent agencies and their independence, does it fit to the principle of division of powers according to the Ukrainian constitutional structure? And now it is a great honor to present another speaker of our conference, professor from Gdansk University, Anna Rytylova. She is the colleague of our university, and it is not her first time in our conference, and therefore we're very eager to hear about the current developments and problems. We know that problems exist in Poland, but maybe there are some new turns in terms of government in Poland.
Lithuanian introduction, but the problem is that at the same time we have two possibilities, to listen in English and in Lithuanian. So a lot of things that I said about you and about your presentations, they're also translated into English. But welcome, we are very happy to see you, and please, the floor is yours.
Thank you very much. Before I start, I would like to congratulate all of you, all the organizers, on the organization of the conference this year. And I would like to thank you for the effort you put in it. It was probably much more difficult than usually. In particular, I would like to thank to all dear colleagues from Mykolas Romeris University. It's always a great pleasure to see you, even online, and it's a great honor for me to speak today. So, as Professor Toma Birmontien has already mentioned, I will talk about the independence of courts in Poland, and I would like to show you a presentation, so maybe it will be a bit easier to follow what I'm talking about. So if you could wait a moment, we'll maybe manage and then... Okay, so... Okay, can you see the presentation? Yes, may I? Yes? Okay, so...
Yes, we can see. Okay.
Okay, thank you very much. Yes, so the topic of my presentation is the independence of the judiciary in Poland in the light of recent reforms. Recent, so I mean the reforms that were implemented after 2015. That was a very special year because after the parliamentary and presidential elections in Poland, the legislative and executive powers were concentrated in the hands of one political party. And in the following years, that party introduced a lot of reforms, and very important ones were just concerning the judiciary. So what is very important about in the context of the independence of the judiciary in Poland is the constitutional background. So we have two articles, Article 10, that guarantees the principle of the division of powers in Poland, the division and the balance of powers, the legislative, executive, and judicial power. And it should be also mentioned that the Constitutional Tribunal has several times pointed out that this division should be treated in a very strict way in regard to the judiciary, as the judiciary is particularly connected with the protection of human rights and freedoms. That division of and separateness, we even can say, of the judiciary is strengthened by Article 173, which states that the court and tribunals shall constitute a separate power and shall be independent of other powers. We have that balance, but anyway, the other authorities should not affect the judiciary in regard to activities concerning the jurisdiction. So it can be only administrative influence of the executive or legislative power. Just already in 2015, the first reforms concerning the judiciary concerned Constitutional Tribunal. I wouldn't like to talk about that in a great detail because that was the subject of my presentation during the conference in the Lithuanian Parliament 3 years ago. But just to mention that the Constitutional Tribunal is not only a constitutional court, it does not only conduct the review of law, a constitutional review of law in Poland, but has also some other competences. As you can see, the Constitutional Tribunal is composed of 15 judges chosen by the Sejm, and the Vice President and the President of the Constitutional Tribunal shall be appointed by the President of the Republic from among candidates proposed by the General Assembly of Judges. That's important because of in the context of the reforms that were implemented in the following years. So just to maybe remind shortly the main points of the reforms implemented in 2015, 2016. So the first problem concerned the composition, as the new parliament in December 2015 did not recognize the judges legally appointed by the previous parliament. So the problem concerned 3 judges who didn't and still cannot perform their duties as the President of the Republic refused to take oaths from them. And what's more, the parliament appointed other 3 judges for already occupied seats in 2015. That the presence of these 3 new judges provoked a discussion over the correct formation of the adjudication panels and consequently the legality of judgments passed by the Constitutional Tribunal. So when we have such controversial decisions of the Constitutional Tribunal, like the decision that was issued yesterday evening concerning the unconstitutionality of abortion law, this is the argument presented against the validity of the Constitutional Court's judgments. The second problem was concerning the president, the way of appointing the president of the tribunal, because in December 2016, the president of the tribunal was appointed by the president on non-binding regulations that came into force 2 weeks later. And at the same time, it was not, this appointment was not preceded by the resolution of the General Assembly of judges of the Constitutional Tribunal that is required by law, as we saw in the previous slide. And the third problem concerned the series of the so-called recovery laws. Between December 2015 and November 2016, the Parliament adopted 6 laws amending or introducing entirely new regulation concerning the Constitutional Tribunal. The most controversial one was the amendment adopted in December 2015, which introduced a set of procedural rules which would block the possibility to adjudicate by the tribunal. That amendment was considered by the tribunal unconstitutional in a judgment issued in March 2016. That was a judgment issued directly on the basis of the provisions of the Constitution. However, the government refused to publish the judgment in the official journal of laws, and it was formally not binding. It was something that deepened the constitutional crisis around the Constitutional Tribunal. At present, the situation is that there are very serious doubts as to whether the Constitutional Tribunal is still performing its basic function of conducting the constitutional review of law. It's also very disturbing that the current situation has generated a very significant decrease in the public's trust in the status and in the role of the Constitutional Tribunal as such. So the next year, 2017, that was the year of the reforms of the Supreme Court and Common Courts. So when it comes to the Supreme Court, in December 2016, a new law was adopted on the Supreme Court. And it's important to say that the new law has increased enormously the influence of the Minister of Justice, who since 2016 is also a general prosecutor on the activities of the Supreme Court. So it lowered so the essential changes introduced by that law influenced both the status of the judges and the organization of the Supreme Court. In particular, it lowered the retirement age from 70 to 65, which resulted in the forced retirement of 27 judges of the Supreme Court, as it had a very immediate effect. And the other change was new thing was the establishment of 2 new chambers of the Supreme Court, the disciplinary chamber and the extraordinary control and public affairs chamber. The first one was set up to discipline Polish judges and was quite obvious that in particular it was to punish those judges who were critical of controversial reforms concerning courts. The second one, the second chamber was, among others, to consider extraordinary complaints, as well as consider protests against the validity of elections and national referendums, as well as to confirm their validity. So that is something extremely important for the political powers. In January 2018, the General Assembly of the Supreme Court passed a resolution in which it stated that the new law, the new act, were proceeded and adopted in violation of basic rules of legislative procedure without due consultations, disregarding submitted legal opinions. The court pointed out that the new regulations were in many aspects inconsistent with the Constitution. In particular, they violated the principle of the division of powers and the independence of courts, the independence of judges. The Supreme Court also stated that the new chambers are chambers only by name, and in fact they constitute two separate and independent courts which are unknown to the Constitution, and chambers that will exercise control over common courts and the Supreme Court. Also, the Venice Commission in December 2017 formulated critical remarks about that law. It pointed out that the creation of the new chambers composed of newly appointed judges and entrusted them with special powers puts these chambers above all others and is ill-advised. The proposed system of the extraordinary review of final judgments was regarded by the Venice Commission as dangerous for the stability of the Polish legal order, especially that this mechanism is retroactive and permits to reopen cases decided long before its enactment. And there were some more critical points that have been presented on the slide. The President of the Republic, as an elected politician, should not have the power to decide on the extent of the mandate of a Supreme Court judge beyond the retirement, for example. On the same year, the reforms were implemented in regard to common courts. In July, there was an amendment to the law on the system of common courts, and the legislative proceedings concerning that law were accompanied by extremely sharp legal arguments. The most important is that that law, the entrance into force of that law, resulted in the strengthening of the administrative supervision of the Minister of Justice over the activities of the common courts, as well as it is in case of the Supreme Court. The minister obtained the arbitrary right to appoint and dismiss presidents and deputies presidents of the court, for example. The new law also established a new office of the disciplinary prosecutor for common courts, who is appointed by the Minister of Justice, and his main task is to investigate possible offenses of judges pursuant to requests of the Minister of Justice and other entities. It also lowered the retirement age from 70 to 65 and provided the Minister of Justice with the power to extend the mandate of a judge beyond the retirement age. So all these provisions were also negatively assessed by the Venice Commission in the above mentioned opinion. And the last authority related to the justice, which has been affected by the reforms implemented in recent years, is the National Council of the Judiciary, the constitutional body which safeguards the independence of courts and judges. According to the Constitution, the National Council of the Judiciary shall be composed of three groups of entities. The first one, as you see, these are people who are in the council ex office. Then we have 15 judges chosen from amongst the judges of the Supreme Court, Common Courts, Administrative Courts, and Military Courts. And finally, there are 4 members chosen by the Sejm from amongst its deputies and 2 members chosen from the Senate from amongst its senators. It's very important because the reform implemented in 2018 concerned the manner of the appointment of its members, the composition of the council. So that amendment, it was in 2017, as you see, provided that 15 members of the National Council chosen from amongst judges shall be chosen or appointed by the Sejm. So that regulation, that solution violates not only Article 187, but it also violates the idea of the council as a kind of a self-government of judges with a mixed composition, and it also, as the National Council is the authority to appoint judges, it also, by providing such a great influence of other authorities on its composition, violates the principle of the division of powers and the principle of the independence of courts. In the mentioned opinion, the Venice Commission in 2017 stated that the election of 15 judicial members of the National Council of the Judiciary by Parliament, in conjunction with the immediate replacement of the currently sitting members, will lead to a far-reaching politicization of this body, which has already happened. And therefore, there's a serious problem now with the legitimacy of the National Council of the Judiciary, composed according to the new rules, to appoint the judges both to Common Court and the Supreme Court. And there is a lot of opinions that question the independence of judges appointed in that way. In 2018, the Supreme Court referred questions to the Court of Justice of the European Union for a preliminary ruling, in which it asked whether the newly established disciplinary chamber is an independent court without the meaning of European law or not. And in the judgment of November 2019, the Court of Justice did not give a direct answer about the nature of the National Council of the Judiciary or the status of judges appointed by its new composition, but it indicated that judges of Common Court and the Supreme Court have the full right to verify the legality of the new National Council of the Judiciary and the disciplinary chamber of the Supreme Court. And it was in response to that judgment, the Supreme Court issued a judgment in December 2019, in which it concluded that the National Council of the Judiciary in its current formation is neither impartial nor independent of the legislature or the executive. Consequently, the resolutions passed by the Council must be annulled, and it also should refer to resolutions concerning the appointment of the new judges to the Supreme Court and other courts. Another important resolution of the Supreme Court was adopted in January 2020, and the Supreme Court once more stated that the disciplinary chamber cannot be regarded as a court under European or Polish law. The Supreme Court also ruled that all judges from the Chamber of Extraordinary Control and 7 judges from the Civil Chamber should refrain from adjudicating, and appealed to all judges appointed by the new National Council of the Judiciary to refrain from adjudicating in cases concerning citizens from the next day, so the 24th of January 2020. At the same time, the Supreme Court stated that the judgments that were handed down up to that date in which judges elected by the new National Council of the Judiciary were ruling should remain valid in order to protect citizens' affairs and their safety. However, the Minister of Justice decided that that resolution of the Supreme Court was not valid, and it introduced even more legal chaos in Poland. On one hand, the disciplinary chamber of the Supreme Court and the National Council of the Judiciary is still acting as if nothing has happened. But on the other hand, some judges appointed to the new National Council of the Judiciary are refraining from adjudicating. So some commentators of public life in Poland are already talking about two legal orders being enforced in Poland at the moment. Additionally, in April 2020, the Court of Justice of the European Union issued an order on the request of the European Commission in which it obliged Poland to immediately suspend the application of national provisions regarding the competence of the disciplinary chamber of the Supreme Court in disciplinary matters concerning judges. Nevertheless, the disciplinary chamber is still working and is still issuing decisions concerning particular judges. A week ago, we had a very controversial decision of that chamber in which it waived the immunity of Judge Beata Morawiec, and it was met by a lot of protest from Polish society, from professors of constitutional law. But that is the situation that we have in Poland at the moment. Yeah, we have to wait to see how it will continue. Thank you very much for your attention.
Dear Professor, thank you very much for your so interesting presentation. Ir ką, mėly kolegos, dabar.
Colleagues, ladies and gentlemen, it is my huge pleasure to present to you Mantas Jarukaitis, who's very well known in the lawyers community in Lithuania and whose departure to Luxembourg is loss to the Lithuanian legal community and a victory for Europe and for ourselves as well, because Mantas works in a court which adopts very important decisions for Lithuania. Irmantai, can you hear us well? Yes, I can hear you well. Can you hear me? Yes, we can. We've listened to a presentation on the situation in Poland, and the Court of Justice of the European Union really looked into those issues, so it will be indeed very interesting to hear what our colleague will tell us. The Court of Justice of the European Union is the agency he represents, and he will speak about the impact of the EU and EU law on national constitutions, including the principle of division of powers. I observe the followers on YouTube platform of this conference, and I see that the number of followers, and now that Mr. Jarukaitis starts to speak, the number of followers has increased largely. We are looking forward to your presentation. Thank you very much indeed. I hope I will meet your expectations. Good morning. Good afternoon, ladies and gentlemen. First of all, let me thank the organizers of the conference for the opportunity to, in a way, come back to Lithuania in virtual terms. It is a huge pleasure to take part in this conference. I'm sorry I couldn't join you earlier because I'm back from a debate on a court case. I would like to congratulate you on the Day of the Constitution, and I have no doubt that the presentations we had today and the debate that has been here so far demonstrates how important the Constitution is for us. It is, in fact, the fundamental law based on which we live, and if we look into the global context, we will agree that our life conditions are quite good. My presentation will focus on the impact of the EU membership and EU law on national constitutions. I will speak in 4 parts. My presentation consists of 4 parts. First of all, I'll speak about the EU itself, the ways to conceptualize the EU in the context of today's topic. Then I will talk about the membership of EU and the impact of EU law on the principle of separation of powers. This relates to the relations between the legislative and the executive. And as the previous colleague has told us, recently there are numerous changes on ensuring the independence of national courts. And last but not least, I will try to talk about the impact on other areas from EU law, such as preservation of fundamental rights and the role. And I will start from the EU in modern context. There would be no use to talk about the EU or United Nations in this context, but it would be very useful to talk about the EU because, as we know, the EU is a specific organization, has its own specificities, and in the modern context there are several important characteristics which make us evaluate the impact of our EU membership on the national constitution. First of all, this is the real and extensive public authority of the EU institutions. Of the three branches of power, including in the executive, the legislative, and the courts, the judiciary, these areas are very vast. If we compare the EU with the UN, in UN there's a very small functional area, which is the UN Charter, which is a very small area, let's take a UN resolution, any resolution. Has it made an important impact on us? No, it would be difficult to find the real impact from UN resolutions of the Security Council. Whereas when we talk about the public authority of the EU, this impact is huge. The second aspect is the implementation of the public authority. We are talking about the majority principle of decision-making. At the national level, we talk about the Seimas, which mostly makes decisions on matters. This is the essence of democracy, in fact, and the same can be said about the EU level. As a rule, both the Council, when it votes, decides on matters by qualified majority, and the European Parliament also decides on matters by making decisions based on the majority principle. Of course, the foreign and security policy and indirect taxation are areas where this rule does not apply. The EU citizenship is also playing an independent role in developing the political society of the EU. We can feel the impact because there's the principle of direct effect and premise of EU law. So there's a cumulative result of these features, and this result is the fact that many practitioners and scientists say that the EU is a community of undefined objectives. This doesn't mean that the EU doesn't have any objectives at all. This means that these objectives are very vast indeed, hugely vast. And if we look at Article 3 of the agreement of on the EU,
Gerbiami klausytojai, gerbiami.
Ladies and gentlemen, colleagues, please accept our apologies for temporary problems in the connection. As for the constitutionalism and the application of this constitutionalism idea in the EU, this is very important because the fact that this impact is in place forces us to think that there's some logic behind and rationale behind talking about the EU as a constitutional community. However, we need to define what do we mean when we say there's a constitutional constitutionalism. What is constitutionalism to us? There are many aspects of this, and first of all, that's constitutionalism as limitation of the powers of public authorities. Historically, this is the oldest dimension of constitutionalism. Ever since the Magna Carta, there's a concept that we have to have an opportunity to protect ourselves from the public authority, whatever it is. And we talk about the individual freedoms and rights. Our constitutional court has said that the Constitution is an anti-majority act, an act which purports to safeguard the rights of the individual. In the state context, historically, this is the most mature dimension of the EU constitutionalism. Ever since the 1970s, 1960s, the jurisprudence of the EU demonstrates that every individual has to have the means and tools to protect himself or herself from the authority. The second dimension is, in fact, the community dimension. A state is a community, a political community of sorts. It is united by a principle of solidarity. All constitutional positive obligations, such as an obligation to create a healthcare system, an education system, and to develop them, are covered by this dimension. It is a fact that a society as such has some common interests. And of course, these interests are part of the Constitution and have to be protected by the Constitution. An elementary example of this conflict between the two dimensions is a simple one. On the one hand, a person has the right to have ownership, and on the other hand, the society has a right to take over this ownership for common needs, should need may be, and of course with the due compensations. And the third dimension is the constitutionalism as a system of discourse. The Constitution creates a certain institutional normative system in order to balance the two goods, the individual needs and the public needs. In the EU, this dimension is maturing, as we will see later on. In conclusion, we can say that constitutionalism is a reflection, an operational system of the political community. And in fact, it reflects the fears of the minority and the majority of the dictatorships, and to search for a balance between these fears. Absolute power of minority is not good, and the absolute power of the majority is no good either. So the Constitution tries to strike the balance between the two fears, the fear of the power of a minority and the fear of the absolute power of the majority. The conference centers on the constitutional principle of separation of powers. Therefore, I will now move on to the third dimension, which is the constitutionalism as a system of transformation. And there are three paradoxes in this dimension. The first paradox is that although the principle of division of powers is a fundamental feature of the constitutions of all or nearly all EU member states, the EU itself is relatively not fully based on the principle of division of powers, with the exception of the courts, because the courts, by definition, must be independent. If we talk about the political power, however, and limitations between the legislative and the executive in the EU, there's no such direct principle in the EU. The European Parliament and the Commission are executive powers. The Commission, in fact, are more in a way executive institutions. The European Parliament and the Commission and the Council are both executive powers. How does the principle of separation of powers look there? Well, because of the origins of the EU, as we know, in international foreign relations are part of the work of the executive. Historically, while the European communities were not supranational, this choice was a logical choice. However, later on, when democracy was questioned of the EU, the decision was made to expand the powers of the European Parliament in order to compensate for the lack of democratic legitimacy. However, conceptually, when the European Parliament was included into the playing field, both the Council, the European Parliament, and the Commission are executive powers, even though they are some of them are part of the legislative process. There is some substitute, the principle of institutional balance, developed by the court ever since 1958, where the court decision says that each of the communities of the European Union and each of the institutions of the European Union have to work in the jurisdiction and within the competences defined in the establishing treaties. Paradox number 2. Even though the EU is not fully based on this principle, the membership of a country in fact creates dramatic conceptual changes in the organization and implementation of public authorities at national level. For authorities, that's no problem because they know the vertical separation of powers between federation and federation units, while in other countries, non-federal countries, this does not exist. So there's a vertical dimension of organization and implementation of power. When a country exceeds the EU, some part of powers of public authorities are transferred to the supranational level. In Article 4 of the Lithuanian Constitution, it says that supreme sovereign power of the nation shall be exercised directly or through its own, and I highlight that, its own democratically elected representatives. And Article 5 states that the state government in Lithuania is implemented by the Seimas, the President of the Republic, and the government in the court. And this is exhaustive. While EU membership means that a part of national institutions, there are also supranational institutions that also implement those classical powers. In Lithuania's case, this transformation is reflected by the act of the Constitutional Act on states' membership of the EU, and in particular Article 1, which says that the Republic of Lithuania, being a member of the European Union, shares or entrusts to the European Union the competence of the state institution. In this case, we can see there's a principle of transformation of the democratic principle, that our political community is becoming part of the wider EU political community. There are two sides to the medal. First, as citizens of Lithuania, we now have more opportunities to take part in EU-wide decision-making. However, on the downside, the majority principle means that we have to remain in the minority, even if the minister representing a Lithuanian person may not defend the position of Lithuania fully, and if the majority adopts a decision that is not useful for Lithuania, still Lithuanians will have to abide by it. Now let's move to the horizontal change in the balance of powers, in particular the changes in the powers of the Seimas and the government. The origins of these changes lie in the EU Treaty on the EU, Article 16.1 and .2. As you can see on the slide, and it is quite obvious that the Council, jointly with the European Parliament, exercises legislative and budgetary functions. It shall carry out policy-making and coordination functions in accordance with the conditions laid down in the treaties. The Council shall consist of representatives at ministerial level of each member state, who may commit on behalf of the government of its member states and vote on its behalf. So, in terms of EU law, when a minister comes to the EU, he becomes a legislator. Article 67 of the Constitution of Lithuania says that the Seimas is empowered to legislate and approve the state budget and determine the state taxes. The Constitutional Court of Lithuania in 1995 clearly stated that the Constitution of the Republic of Lithuania does not provide for the delegation of the legislative powers. In Italy, this is not the case. A large part of the EU legislation is implemented on a national level by the government, because they allow for the delegated legislation. In our constitution, it is clear that this is not possible. It's a very meaningful change. Before the accession, the government did not have these powers to legislate, whereas after the 1st of May 1994, the government acquired these rights. In practical terms, what does it mean? It's very important. I will give you two examples. Restrictions on fundamental rights in the practice of the Constitutional Court. As we know, only the Seimas and only by law may limit the fundamental rights, and the taxes can also only be established by law. But now, when the government has the power to legislate at EU level, this is changing. I give you the example from Article 113. The Council is entitled to adopt provisions for the harmonization of legislation on turnover taxes, excise duties, and other forms of indirect taxes. This regulation, which creates VAT or excise taxes, and the state can no longer make decisions on whether they may have such a tax or not. I'm not even talking about the details and the main elements of the tax and other specificities and specific factors. The Constitutional Court of the Republic of Lithuania, after Lithuania's accession to the EU, started formulating the doctrine of reinterpretation of the Lithuanian Constitution, and it started saying that what was a fact before the Constitutional Court on Lithuania's EU membership may need a review, because the Constitutional Court on our EU membership is a systematic amendment to the Constitution. Therefore, the Constitutional Court, in a decision of 2006, of the 26th of September, said that there's a new doctrine on taxation. It's no coincidence that when there was a debate on the constitutional amendments and their need, there were many voices saying that, on the one hand, the government powers deriving from EU law are understandable, but on the other hand, some compensational mechanisms are needed. Notably, a large part of the EU member states have such mechanisms. And this is no coincidence. This is meant to diminish the impact on the principle of separation of powers. And this is why we have the Constitutional Act on membership in of the EU, Article 3, which creates a new mechanism which authorizes the government to consult the Seimas of the Republic of Lithuania in the areas where decisions are made by the Seimas, as it has a certain competence. The Article 27 of the Statute of the Seimas is regulating that area. There was an interesting debate, as far as I remember, on how far the Seimas position should obligate the government to act as the Seimas would like to. If we look at Article 6, we will see that of the Constitution, it says that the Seimas may recommend to the government. So this means that the government doesn't have to abide by the decision of the Seimas. The idea was to take into the view the decision-making process in the Council. The states agree on a variety of matters at the same time, and the decision was made to follow some of other EU member states in this model. The government is left with a certain negotiating mandate, for some negotiating freedom, depending on the importance and relevance of the matter. And given that the government is constantly in process of negotiations, so this freedom of negotiations is very important for the government in order to ensure the interests of the Republic of Lithuania. This is why the strict duty to abide by the Seimas recommendations under Article 6 of the Constitution is no longer applicable. Paradox number 3, which I noticed while reading a variety of research papers from Lithuania, is the fact that so far there are very few debates in the academic sphere on the paradox number 2, on the changes which have been inflicted by our EU membership to the organization of power, and as it was defined in the Lithuanian Constitution. Because in some cases, when you read a variety of research papers on the principle of separation of powers and on associated matters, you will read something about only general comments on what the EU membership is changing for us, and you may make a conclusion that the Constitution before 2004 was way different. I believe that it's possible to write a lot about that subject, because comparative analysis could be employed. The general constitutionalism principles can be employed to evaluate various changes, including the evaluation on the Article 3 of the Constitution, and to it's possible to see whether the Seimas statute, Article 21, the many decisions in the Seimas are not adopted by the Seimas itself, but rather by the Committee on European Affairs and Committee on Foreign Affairs. Whether they truly represent the Seimas is a question. We understand that decision-making in a committee is not really a decision-making on the level of the entire Seimas. This also creates huge changes if we look at that through the prism of parliamentarism. A second aspect which I want to deal with is associated with the principle of division of powers, and this is institutional independence of national courts in EU law. This is a new phenomenon in the EU, and it derives from 2018. If we look at the situation before the Lisbon Treaty, before the 1st of December 2009, we will see that the EU Court of Justice mostly talked about the national courts in prejudicial proceedings context. In the context of the Article 267 of the Treaty on the Functioning of the EU. So both in Lithuania, we have two cases where individuals applied to the court, to the European Court. The court had to define the criterion of independence and the court itself. The latest decision, which codifies and develops this practice, is the decision of February from the Grand College in the area of Banco Santander. Notably, if the Court of Justice rules that the national institution is no longer a court, there are only procedural impacts from that. The law will no longer look into the application to make, the court will no longer look into the application to make a decision, to make a ruling. When we talk not about the courts, this is the decision of the state as to how to organize its institutional system. Then the Court of Justice only says that it can be approached by the court only. In 2009, an essential change was made when the Lisbon Treaty, Article 19, was supplemented by subpoint 2, where member states had to ensure the protection in legal affairs. This reflects the fact that everyone agrees that EU law functioning depends in large measure on the national courts, and national courts are in fact EU courts because it is they who apply the EU law on the national level. Another important matter was decision of 2018 on the judgment on the Sinisa dos Jueces Portugueses, the Portuguese judges. The judge wages in Portugal were largely diminished, and a court in Portugal asked for a prejudicial decision. It demonstrated the link between the wage reduction and the EU law. It said that the wage reduction was mostly impacted by EU measures because in order to receive economic support, the EU asked from Portugal to take certain measures. Of course, those messages were abstract, and there was no direct encouragement there to reduce wages for judges. If we look at the judgment itself, we will see that the link with the EU law is defined in a vast abstract terms. It is said that member states have to ensure the independence of justices of national court in areas which are covered by the EU law. This is a very wide definition if we compare it to the Charter, Article 51, which says that in order for the Charter to be applied, this has to be implemented at a national law level. So this judgment is based on the idea that the EU is based on the principle of the supremacy of law and of EU law. In order for the EU law to be functionally implemented at the national level, the national courts have to be independent. As a result of this judgment, we can see an important impact. In academic literature, when I read comments to this judgment, before that judgment, national legal system organization was the competence of a member state exclusively, with the exception of some sort. However, by this judgment, the court has determined that the national courts are part of the consideration of Article 19 and the Charter Article 57. Irmantas, I'm sorry, but we get signals that if you may, you would end your presentation, because your presentation is very interesting, but still we don't have time. And okay. As for this judgment, it is very important, but we can say that the expectations related to that decision were and are still very high. The previous colleague spoke about the situation in Poland, and in this case, we need to explain something in order for your doubts to be dispelled. And I need to explain to you the implementation of this article in some situations. We need to speak about two procedures, different procedures at that. On the one hand, as we know, in the EU, there's a procedure of violation which may be started by the Commission or any member state against any other member state. In this case, when this procedure is started, we can take an example of a decision Commission against Poland on pensionable age reduction and on Poland President's discretion to prolong the term of authority of the judges. The Commission applied the court, and the Commission is not bound by procedural any limitations insofar as the size of violations. So it's up to the Commission to raise any aspect in the procedure of a violation, and the court will have to look into it. Most of the court cases in the Court of Justice come through the prejudicial decision procedure, where national courts raise matters and raise questions. In this case, the opportunity to answer these questions depends on the matter of dispute. If we take a case with the wages of Portuguese judges, the matter of dispute was associated with the principle of independence of judges. However, there are many cases where national courts raise question certain explication of EU documents, directives, and so on, and they concurrently raise hypothetical questions on some aspects in member states. In this case, it's obvious that the Court of Justice refuses to answer those supplementary questions because, based on the court practice, the procedure for prejudicial decision is not consultative. The decision has to help solve the case. For this court, the Grand College decision in Mastologis case is important because this is where the court has an explicated understanding of how it sees the situation. It says that there may be two situations where the court will answer these questions. And the first situation is where the freedom, independence of judges is ratione materia, matter of dispute. And in this case, let's say there's a judge who says, I was brought to court because of jurisdiction activities. And when you look into that case, you violate the principle of independence of a judge. And this is the objective of the matter of the case. And there are also cases where in procedural matters, in solving procedural matters, the aspect of independence of a judge may also come up to the fore. Let's say the court of a higher instance decides issues on the legality of composition of the court of lower instance. And then the independence of courts or judges may also be raised. The court of the EU has identified these matters, and based on this, the Court of Justice will develop its practice further on. Since I don't have any more time, I will leave you at that, and I hope for a debate later on.
Dear Irmantas, thank you very much for returning back to Lithuania, at least online. We really miss you very much, but we are very much critical. In Lithuania, we have discussions. On EU law and its constitutional law. Vertical dimension of the EU has scared the UK actually. Therefore, we need certain boundaries here. The EU treaties can be considered as constitution, but the boundaries of that constitution are very wide. Therefore, in the future, the case of Britain will affect the EU. Well, you lost your colleagues, and the EU law will face certain changes. Thank you very much once again. It was a great pleasure hearing you and hearing your insights. And we will be considering to devoting more attention to the law next year in our conference. Now I would like to present another speaker who will be speaking about a very distant country, the United States of America. We are glad that a famous constitutional lawyer who has published a lot of important works dedicated for amendments. He's Richard Albert from Texas Austin University of Law. Actually, he's a master of Constitution in the US? Well, since the situation.
I am the William Stamps Farish Professor in Law and Professor of Government at the University of Texas at Austin. I want to begin by wishing you a very happy Constitution Day. Happy 28th anniversary to the Constitution of the Republic of Lithuania. Let me now, if I could, please share with you my screen. Wonderful. It is for me a great joy and honor to have the opportunity to participate in this important global conference on the constitutional separation of powers. I thank the Parliament of the Republic of Lithuania, the Lithuanian Bar Association, Mykolas from Marist University, my dear friend and colleague, Professor Dr. Judge Toma Birmontiene, Professor Dr. Agne Varonaviciene. Thank you to all for inviting me to participate in this truly important and global conference. The subject of my remarks today is the separation of powers in federal systems, crisis, consensus, confrontation. And I'll begin with a word about a peculiar form of the separation of powers, the vertical separation of powers, which of course we can refer to as federalism. Then I'll discuss how to manage crisis in federal systems. How do they manage to do that? It's very hard to do when you have separated powers in a federal state and you're confronting a crisis. Then we'll talk about consensus in federal systems. It's very hard to achieve consensus in federal systems precisely because of the separation of powers. We'll then move on to discussing confrontations in federal systems. Confrontations are inevitable in federal systems, and they pit the state versus the sub-state. And then a word or two to close on federalism in times of crisis, a true balancing act. Around the world today, there are about 28 countries that we can define as federal systems. And together, they represent about 40% of the world's population. Countries like Canada, the United States, Brazil, Australia, India. Why, might we ask, do constitutional designers choose to create federal systems? What values does that form of separation of powers serve? Well, the answer is that it serves the very same purposes and values as is served by separating powers at the same level of government, where we have a national government composed of an executive branch, a legislative branch, a judicial branch. We separate powers to achieve the very same purposes as we do when we separate powers vertically in a federal system of government. We separate powers to diffuse power, to guard against the concentration of power in the hands of one body. We separate powers for accountability, to give notice to the people about who does what. We separate powers in the service of competence because we assign governmental tasks to the body best equipped to do those tasks. And we separate powers in the service of independence and recognition of the value of independence, to protect the separate spheres of jurisdictional responsibility between state-level institutions and sub-state-level institutions. Now, of course, there are other considerations, other reasons why we separate powers vertically and also horizontally. Questions of comity and mutual respect, subsidiarity, when we talk about the vertical separation of powers, confederalist versus centralist arrangements. These are the reasons why the purposes for separating powers vertically in a federal system. An important question to ask is, how do federal systems respond to crisis? Now, before we can address the question how federal systems respond to crisis, we must define what a crisis is. And for that, I want to turn to the work of two of my colleagues, Jack Balkin and Sandy Levinson, drawing from their paper called Constitutional Crises, published in 2009. They identify three kinds of crises. One, where there's a declaration of a state of exception. This occurs when political leaders publicly claim the right to suspend features of the Constitution in order to preserve the overall social order and to meet the exigencies of the moment. 2, where there is excessive fidelity to a failing constitution. And this occurs when all political actors comply with their constitutional duties and roles, but their respect for the Constitution fails to resolve an existing political crisis, and that leads to disaster. And 3rd, struggles for power beyond the boundaries of ordinary politics. This occurs when political actors proclaim their constitutional fidelity, but they disagree about what the Constitution requires and about who holds the appropriate degree of power. Each side claims that they are acting constitutionally and that the other is violating the Constitution. Each of these 3 is a different form of a constitutional crisis. Federal systems operate in strange ways because sometimes they will operate to exert centrifugal forces, and sometimes they'll operate to exert centripetal forces, centrifugal and centripetal. The key for a federal state in responding to a national crisis is to be able to draw on a certain number of tools that are available only in the center, only at the state level. That requires legal coordination. It requires a certain measure of moral suasion, perhaps some popular appeals, and sometimes recourse to military force. Think, for example, of the current public health crisis that has swept across the globe, COVID-19. Federal states, it turns out, are not performing well in managing this public health emergency. Now, it's true, some states are doing well, but many of the worst performing countries in the world are federal states. There's little, perhaps, to no capacity to coordinate in the face of this COVID-19 crisis, and that is making countries like Mexico, a federal country, react very poorly to this crisis. Sometimes there's a lack of appreciation of the costs, the consequences, perhaps even of the threats that the virus poses to the population. This is one of the problems that is confronting Brazil. Not only a lack of coordination, but there seems to be a lack of attention to finding a way to respond to the crisis in a national manner. In the United States, there has been no national mobilization against the crisis. Most of the work has been left to the states. And when that happens, it's just very hard to attack what is truly a national problem. So the point is simply this. The point is that in moments of crisis, like the crisis that we're living right now around the world, federalism can sometimes make it very difficult to respond successfully to the crisis. And one of the reasons why it's often hard to respond to crises in federal systems is because it's hard to create moments of consensus. It's hard to build the consensus necessary to create a national response to the problem. Now, if you look at the design of federal constitutions, you can see quite clearly how and why consensus is hard to achieve. Just think of how hard it is to amend federal constitutions. Federal constitutions are designed to fragment powers across several different sites of authority at the national level and at the subnational level, at the state level and at the sub-state level. This is a core design strategy in constitutional democracies. And the purpose for fragmenting power, the power to amend a federal constitution, the purpose is to make sure that when there is an amendment, it reflects the broad, representative, sustainable consent of the people for a change to the Constitution. So no wonder federal constitutions make it very hard to amend the federal bargain. Think of the many various ways that federal constitutions fragment power when it comes to the amendment power. They fragment power across political parties by requiring, for example, supermajorities to agree in a national legislature. Well, when you require supermajority agreement, it's likely going to be the case that you will need cross-party approval. That's a fragmentation of the amendment power across political parties. We see this in the Japanese amendment rule. You can also fragment power in federal systems when it comes to amendment by fragmenting power across branches of government. You might give the authority to initiate an amendment to one branch and the authority to ratify the amendment to another. Or you might give the power to initiate an amendment to two different branches, or even more than two different branches. The point is that you fragment the power, you separate the power to amend the Constitution, and that makes it harder to amend the Constitution. A third way to fragment power in a federal jurisdiction is across cultural or ethnic identities. So for example, the Constitution of Bosnia and Herzegovina authorizes amendment in a parliamentary assembly whose members must represent different ethnic groups. This is a clear example of the fragmentation by design of the amendment power across cultural or ethnic identities. One last example, one can fragment the amendment power across time in federal jurisdictions by authorizing amendments to be ratified either within a narrow period of time or over certain longer period of times where you require multi-generational participation in the ratification of an amendment, fragmenting the power to amend the Constitution between a group at time 1 and another group at time 2. Federal systems fragment powers of amendment across states, across provinces, across lander. This is simply the federal fragmentation of power. And it's interesting because we see this in federal countries and they operate as protective mechanisms used to protect the interests of regions, of territories, of peoples. One peculiar design strategy that makes it hard to achieve consensus in federal systems precisely because of the separation of powers between the state and sub-state entities is that it gives veto power in amendments to the federal constitution, gives veto power to subnational, sub-state entities within this larger federal structure. A protective mechanism to protect the interests of the state, the province, the lander. Let me give you 3 illustrations. One protective mechanism is a protective mechanism of voice by requiring each province, each state, each lander to be consulted on amendments that concern its own powers. Another strategy is representation. Federal constitutions give sub-state entities representation at the table of negotiation about the amendment. A third strategy is a vote. Federal constitutions give sub-state entities a vote, in fact, a veto over amendments that affect their own powers, their own rights, their own prerogatives in a federal jurisdiction. Think, for example, of the Equal Suffrage Clause in the United States, or the Australian Constitution that does something very similar for states. The goal here you see when the amendment power is fragmented across federal jurisdictions is to foster collaboration and consent with a view toward consensus building. Consensus is very hard to achieve in a federal system. One key feature of federal systems and the separation of powers that really characterizes how they operate is confrontation. This is an inevitable feature of separated powers in federal systems, confrontation between the center and the states. Sometimes confrontation occurs even where the Constitution is designed to avoid a confrontation. How do constitutions try to avoid confrontations? Well, by trying to be clear in how they allocate authority to different branches of government, to different levels of government. Let me give you 3 examples of how federal constitutions try to avoid confrontation between the center and the states. One way is by dividing powers between the state and the sub-state entities by identifying one list of enumerated powers that belongs to one level of government, with a residual clause that says all other powers belong to the other level of government. This is the US example. A second strategy is where you have two lists. There are two lists of separately enumerated powers, one for the state, one for the sub-state entities. And this is an effort to achieve clarity about who can do what. Third, three lists. There is one list for the state, a second list for the sub-state entities, and then a third list of concurrent powers. Concurrent powers that may be exercised by either level of government. The one-list model is evident in the US, the two-list model is evident in Canada, the three-list model is evident in India. Here is the problem. No matter which of these models is used, confrontation will arise. Confrontation will occur no matter what. This is an inevitability in the design of federal systems and the allocation of power, however clear we think the allocation is. But this, to me, you see, is in fact a justification for the centralization of constitutional review in a federal system. This, to me, is a justification for having a court serve as a mediator when it comes to attention between the two levels of government in a federal state. There's always going to be disagreement on who can do what in a federal state. The central government will seek to assert power, the state government will seek to assert power, and it will be inconsistent claims of authority. Someone must win, someone must lose. But who decides? Someone has to decide. It cannot be left to the political process. Here is where the court comes in. Here is where the court comes in with the power of constitutional review to mediate the conflict in federal states on the proper separation of powers between the center and the states. Constitutional review today around the world is under attack. It's called undemocratic. It's called unaccountable. It's called unrepresentative. Well, for me, constitutional review proves its worth in federal systems. Federalism requires an impartial decision maker to mediate conflicts. It cannot be the national government. It cannot be the state governments. It must be a body that is both seen to be impartial and actually is impartial. And that must be a supreme or a constitutional court. So we've talked so far about crisis, about consensus, about confrontation. There are tensions among all three of these points. Because to manage a crisis successfully, federal systems have to find a way to avoid confrontation and to arrive at consensus, some answer about how to meet the moment. But you see, separated powers in federal systems make confrontation likely and consensus unlikely. In fact, the likelihood of confrontation and the difficulty of arriving at a consensus is sometimes what allows federal systems to survive in this body of simmering tension. It's a tension that keeps the balance of powers ever in evolution, with no one level of government ever dominating over the other. It's a life of constant change, most likely incremental change, not revolutionary change. And this constant tension, a productive tension between the center and the states, it keeps federal systems stable. Stable, though always in a certain measure of instability. Now, the tension, of course, is heightened in a moment of crisis because it is here that consensus is needed the most. Yet it is here that the Constitution makes consensus hardest to achieve. And indeed, the effort to arrive at a consensus may, in fact, make the crisis even worse than it is. Think, for example, of secession in Canada and Spain. Think of the Articles of Confederation in the United States. Think of the challenge of climate change. In the United States, because of the difficulty that the national government has in coordinating the states to act together to combat this problem, some states have decided to take it upon themselves to address climate change. And so you see, it is a true balancing act that must be managed when it comes to federal systems and the way they separate powers. To close, let me just once again say thank you for this invitation to join you in this fabulous and important program. I thank all of the sponsors. I thank the hosts. I thank my dear friend, Professor Dr. Judge Thomas Birmontiene. I thank everyone for their wonderful hospitality and again for their invitation to join with you today to say Happy Constitution Day. Happy 28th Constitution Day to the Republic of Lithuania.
Labai ačiū profesoriui Albertui.
Thank you, Professor Albert. Well, it was a very beautiful presentation. I'm impressed in terms of the content. It was interesting. Therefore, I congratulate the organizers who managed to invite the speaker, this wonderful speaker, to the conference. Certainly, there were some problems in demonstrating the slides, and those who see this, who watch the conference live, don't worry, the material will be published. You will be able to see all the slides. If we fail to some of the slides, please don't worry. Everything will be published later on. Well, the conference has its organizers, and they have to be thanked at the end of the conference. I remind that the organizers of the conference include the Seimas of the Republic of Lithuania, Mykolas Romeris University, Lithuanian Bar Association. This conference is a traditional one. I believe that it has been very successful. We have been waiting forward to this event every year. Dear participants of this conference, I'm very happy that there has been a success, because we as organizers were very much afraid for the presentations, the speeches, and the participants. But as far as we get the information, this conference was very interesting and important. We hope that next year, when we meet, we will be able to see each other and to see each other physically. Now here we are ready with all the defense, all the protection measures. The hall is big, but in future next year, we will be having next autumn, we will be approaching the Constitution Day. So, well, this is not an issue of constitutional law, but let us hope that science and other spheres of life will do their make their contribution, so that we can meet live next year in order to see people in this whole life, so that we can ask questions and have a discussion. Therefore, we are very early to finish this conference, as traditionally it would take until 5 p.m. But this year, due to the circumstances, we are having a virtual conference, and therefore it makes the conference shorter. I also want to thank the speakers who are still present here, and those who join us online. I also thank Haroldas, who agreed to co-moderate this part of the conference. I thank Agnė Tvarijonavičienė, Director of the Institute of Public Law of Mykolas Romeris University. Thanks to her efforts, this conference was organized. We also thank the Seimas. and especially the staff of the Seimas who agreed to host us here and help us. We thank the interpreters and our technicians who helped to organize this conference. And thanks goes to Aidena Bacevičienė, assistant to the Seimas Committee on Legal Affairs. We hope for her support in the future to come. Thank you very much once again. And I hope to see you next year too. Thank you.